Welcome friends, myself Amit Kishore, Assistant Professor, Department of Political Science, KSS College, Lakhisrai. For B.A.part-2 student under paper Indian Government and Politics, today we will be discussing the topic fundamental rights. Under fundamental rights, I will be discussing what are fundamental rights, why it is so important to individuals, what are the nature of our fundamental rights, is there is a difference between fundamental rights and legal rights, what are the relationship between fundamental rights and judicial review, can the parliament can amend our fundamental rights. At one time we are saying they are fundamental rights, they are so sacrosanct. But can the parliament can amend the fundamental rights? Here we have a big debate. Kesavnanda Bharti case, Golaknath case, I'll be discussing it. And classification of fundamental rights. Under classification of fundamental rights, this topic I may discuss in another lecture. So today I'll be focusing on all the above topic. This topic, if the time permits, I may discuss it today or in another lecture. So let us start our discussion on what are fundamental rights. First, let us see the background from where the founding father of our Indian Constitution drew its inspiration of incorporating fundamental rights in our Constitution. It is the US Constitution. The US Constitution 1787. The US Constitution is the first written constitution, and under the Bill of Rights, the fundamental rights are incorporated. Inspired from the US Constitution, the founding father of our Constitution Assembly incorporated these fundamental rights under Chapter 3 of the Indian Constitutions. But what are fundamentals, right? The word fundamental suggests that rights are so important that the Constitution has separately listed them, they have been listed them and made special provision for its protection. And also they have made a provision that they are not to be violated by the government. So three things are important: separately listed them, special provision so that they are enforceable in the court of law, and third, they have also ensured that the government of the day or the state of the day does not violate them. They are so important. But now the question arises, why it is so important? In any individual cannot attain its physical, mental, spiritual and full potential without these rights. These rights gives an opportunity to the individual to allow them the space to grow themselves physically, mentally, as well as potentially. And also, when we talk about democracy, if there is no any rights to the individual, democracy doesn't make any sense. Democracy is not only a procedure of law, rather democracy is the cluster of three ideas: liberty, equality and justice. And liberty and equality are ensured to the individual by providing these fundamental rights. So fundamental rights are very important to the individuals. Here I am using the expression individual. So these rights are available both to the citizen as well as to the non-citizens. Now the question arises, what are its nature of fundamental rights? First, these rights are to the individual, not to any organization or association. Second, they are enforceable in the court of law. Third, these rights are against states except right to untouchability and right against exploitation, which are against both the individual and the state. And third, these rights are limitations on the state power so that the state does not become autocratic or so strong that the very purpose for which the state is created is defeated. So there is an equilibrium between the state and the individual. Certain space is given to the individuals where the state does not encroach upon, and these are ensured by fundamental rights. Under the nature of fundamental rights are not unlimited. If they are so important, that doesn't make it unlimited. They can be restricted. And the constitution provision, the constitution itself contains the ground on which the fundamental rights can be restricted. Further, it also empowers the parliament to impose the reasonable restriction by enacting the law. And the most important part of the nature of the Indian fundamental rights, that under Article 32, which makes the Supreme Court the protector of the fundamental right. What does it mean, the protector of the fundamental right? Protector of the fundamental rights, that if any of these rights are violated by the state or the government or the individuals, the aggrieved person, means the person whose fundamental rights has been violated, they can straightway approach to the Supreme Court under Article 32, file a petition and get its rights due back. So it's very, very important. Now the question arises, there is a difference between a fundamental rights and legal rights. Legal rights, example Article 300A, which ensures right to property, and Article 326, right to vote. But these are legal rights. So what is the difference? The difference is that ordinary rights can be changed by simple ordinary legislative process. The parliament can take away your rights, can amend your legal rights. But for changing in the fundamental rights, they have to go to the constitutional amendment under Article 368. Second, means if any of these rights are violated, an individual can approach to the Supreme Court under Article 32, but for legal right, they can only approach to the High Court or the subordinate court under Article 226. And third, for changing in the fundamental rights, you have to change in the constitutions. So there is a difference between fundamental rights and legal rights. What are the relationship between fundamental rights and judicial review? First, let us understand what is the meaning of the judicial review. Judicial review means power of the Supreme Court and High Court, and not the subordinate court, to declare a law as unconstitutional and void on the ground that it violates one or more provision of the Constitution to that extent of violation. When it comes to fundamental rights, Article 13 of the Constitution explicitly confirms the power of judicial review to the court. Means, हिंदी में judicial review को न्यायिक पूर्वावलोकन भी बोलते हैं. Means, if the parliament can make any law and if it violates the constitutions or if it takes away any of our fundamental rights, that law will be not accepted in the simple later meaning of what is judicial review. Now, this is the most important topic of my discussion will be amendability of the fundamental right. On one hand, we are talking about fundamental rights are so sacrosanct that we have a special provision of protecting it. But can our parliament can amend the fundamental rights? Can our parliament can amend our fundamental rights? There is a big debate. Perhaps you may be knowing the Golaknath case versus State of Punjab 1967 and the case of Nanda Bharti and the State of Kerala 1973. So let us start. I'll be discussing in detail about what is the whole history about amendability of fundamental rights. Here I will remind you what the Article 13.2 says. It defines what is law. What is law? It defines what is law. Article 13.2 states that state shall not make any law that takes away or breach one or more of the fundamental rights. If any such law is made, it shall be unconstitutional, void to the extent of its inconsistency with the fundamental rights. Means it simply states that the state will not make any law if it is inconsistent with our constitution, and such inconsistency will be completely not accepted in our constitution. The Supreme Court in the Sankari Prasad versus Union of India 1952, I'll be citing a number of judgments just to explain to you that the Supreme Court also consistently evolved the understanding of fundamental rights and also evolved their understanding that can the parliament can amend the constitutions or change the fundamental rights or not. In number of cases, they have overridden its own decision and provided a new interpretations. And what the interpretation of the Supreme Court says, that is accepted by one and all. So I'll be citing a number of cases. So I was talking about the Supreme Court in the Sankari Prasad versus Union of India 1952 case held that Parliament enjoys two types of legislative power. One, ordinary legislative power, and two, constituent legislative power given under Article 368. Any enactment of the Parliament made by the virtue of its ordinary legislative power is called law, and it comes within the meaning of expression law as it finds in Article 13.2. Means it simply says that in Sankari Prasad versus Union of India, it says that the Parliament has two types of legislative power. One is ordinary legislative power and second is constitutional legislative power under Article 368. So if ordinary legislative power, if it makes any law, the Supreme Court will scrutinize whether that law formulated by the Parliament is consistent by the Constitution or not under Article 13.2. And they will not look into what amendment has been made by the procedure of Article 368. Thus, the court upheld the constitutional validity of the First Amendment of 1951. The Supreme Court consistently maintained the above interpretation of the case, means up to Sajjan Singh versus State of Rajasthan 1965, means from 1951 to 1965, the Supreme Court was of the view that there are two types of legislative power to the Parliament. One is ordinary legislative power and second is constituent legislative power. If ordinary legislative power they exercise it and if they make any law, we will use Article 13.2 to scrutinize that law. But if any changes is made under Article 368 by exercise of power under Article 368, they will not going to look into it. This is the stand of Supreme Court regarding the power of the Parliament to amend the Constitution till 1965. That was clear about it. However, a landmark judgment, perhaps 11 judges, in the Golaknath versus State of Punjab 1967, a landmark judgment was given by the Supreme Court. What does it say? The Supreme Court overruled its earlier position and decision and held that Parliament enjoy only one type of legislative power called ordinary legislative power, and Article 368 merely contained the procedure to amend the Constitution and didn't confirm the power of the Parliament to amend the fundamental right. Means it says that earlier the Supreme Court was saying that the Parliament has two type of power, legislative power and second constituent legislative power. But in Golaknath versus State of Punjab, now they are reversing their decision or statement and say no. The Parliament has only one ordinary legislative power and they cannot change the fundamental rights. So therefore what they say is that the no authority functioning under the Constitution, including the Parliament, can amend the fundamental right. Now they are providing a very special position to the fundamental rights and say that the fundamental rights has been given a transcendental position, means overriding position to the fundamental rights, that even the Parliament cannot amend it. The Supreme Court under Golaknath versus State of Punjab state that the amendment passed prior to Golaknath cases shall continue and be valid, but no more amendments shall be passed by the Parliament. The Parliament now further cannot amend the fundamental rights. Now the Parliament, in order to restrict or in order to overcome this judgment of the Supreme Court, passed a 24th Amendment 1971. So after Golaknath case, the Parliament, in order to enjoy the overriding position, passed 24th Amendment. And under 24th Amendment, what are the new changes that has been introduced in our constitutions are, it introduced Article 13(4). What it says that Article 13(4) says that the power of judicial review will not be applicable to the constitutional amendment. Means this power which confirms judicial review to the Supreme Court will not be applicable, which state that nothing in Article 13 shall apply to the Constitutional Amendment Act made under Article 68. Means they say that if we make any amendment in the constitutions under Article 368, this law, Article 13(2), which confirms the judicial power to the Supreme Court, need not be applied. And second, the power of the Parliament to amend the Constitution, and it also amended the title of Article 368. And now it reads, the power of Parliament to amend the constitutions and the procedure therefore. They say, no, earlier you were saying in the Golaknath said that the Article 368 only contains the procedure. Now I will introduce the word, the power of the Parliament. So by 24th Amendment, they have also amended the Article 368. The 24th Amendment, which was introduced by Parliament in order to regain its supremacy over amending the fundamental rights, was challenged in the case of B.A.part-2 cases and State of Kerala in 1973. The court overruled its decision, means against the Supreme Court changes decision, and says that no. Now the Parliament can amend any part of the Constitution, including the fundamental rights, but amending power of the Parliament is not unlimited, is limited to the extent of maintaining the basic feature of the constitution. So the court under the Kesavananda Bharati case and state of Kerala under 1973, they introduced the new term, the basic feature of the constitution, the doctrine of basic feature of the constitution. And it says that as long as the parliament can amend the constitution, all the fundamental rights, but it shall not disturb the basic feature of the constitution. Means they have always erected some kind of barrier to the power of constitution by inventing a new kind of expression. And see, in the number of cases, the Supreme Court over a period of time have defined what constitute the basic feature of the constitution. They have not defined it very clearly and in at what time. But some of the feature of the Indian constitution which they have defined over a number of cases are the supremacy of the constitution, the rule of law, the sovereignty of the constitution, amendment to build a welfare state, secularism, democratic form of government, parliamentary form of government, federalism, balance among the three organs of the state, balance between part 3, that is fundamental rights, and part 4, that is directive principle of state policy. Now, afterward, again the parliament reacted to this judgment of Kesavananda Bharati by introducing 47 Amendment in 1976, which among other things amended Article 368 and introduced Article 368 Clause 4 and Article 368 Clause 5. That the Article 368 Clause 4 state that amendment made under the article shall not be challenged or questioned. Means any amendment done by the parliament shall not be questioned in any court of the law of this country. And Article 368 read that the parliament, that there shall not be any limitation whatsoever to the power, to the amending power of the parliament. Means parliament may have unlisted, not unlisted, means unrestricted power to amend the constitution. In the Kesavananda Bharati versus State of Kerala, the Supreme Court said that Parliament has the power to amend the constitution, but it must be limited to the extent of maintaining the basic feature of the document. The Supreme Court struck down these two clauses of Article 368, Clause 4 and Clause 5 in the Minerva Mill versus Union of India in 1980 on the ground that it took away the power of judicial review which is provided to the Supreme Court under Article 13, and judicial review is one of the basic feature of the Constitution. So the basic feature of the Constitution, that law was struck down. What is the present case? Thus, the present position is that the Parliament can amend any part of the Constitution, including the fundamental rights, but its power is not unlimited to the extent that it does not destroy the very basic feature of the Constitution. So, the Supreme Court for the first time under Kesavananda Bharati versus State of Kerala 1973 introduced the doctrine of basic feature of the constitutions. So, this is a long debate. Can we amend the fundamental rights? And it's over of cases. The Parliament, there was a tussle between the Parliament and the Supreme Court that can we do it, can we not do it? And they have settled. This classification of fundamental rights I'll be discussing in another lecture. My lecture perhaps may be getting longer. For basic understanding of fundamental rights, I may be recommending two books. First, for the beginners, means who may not have read political science at any of its intermediate level, I'll be suggesting read NCERT book, textbook in political science for class 11th, Indian polity. The name of the book is Indian Constitution at Work, textbook in political science for class 11, Indian polity. And for graduate level, means you start with that, Later you graduate over to Indian Polity by Lakshmi Kant. Publisher's name is Tata McGraw Hill. These are the two books sufficient enough to cover your syllabus. Thank you.